First, let me introduce my co-authors in this particular matter. Öznur İnanılır has been a tremendous help, who is here today, and she will make partner at our law firm very soon. She has been working with me on academic matters and on matters of attorney interest for a long time. Sinan Deniz has been in this room last year as well. He was a writer. We're getting very interesting papers published with him, and he is of tremendous help. Ayşe Gizem Yaşar is one of our own from the Bilkent University. She has been a graduate of Bilkent University in 2012, and then she had her master's degree at Pantheon Assas in 2013, then started working with me and has been co-authoring with me ever since. And it is also giving me tremendous pleasure and honor, and I'm sure the same is happening to Osman Gürzumar as well, as we have been teaching competition law in Bilkent University for more than 10 years now, that a lot of our students are coming up with significant academic contributions. Right now, upstairs, Fatih Özkan is delivering a speech, who has been a graduate of our law firm, of our law faculty. Again, just 2 days ago, Zeynep Ortaç, someone who's working with me, was delivering a speech together with me at another university, again a graduate of both the undergraduate and the graduate programs of Bilkent University. So I'd like to also mark Osman Gürzumar as one of the pioneers of teaching students law and economics, and I'm very honored to be a part of that. Now, going to my own topic, I should first explain to you that I don't have a lot of time, so I'm going to very quickly go through what multi-sided markets are, just so that you can follow the discussions more easily. Multi-sided markets are the future, really. Multi-sided markets are where the magic happens, in the sense that instead of the traditional markets, and admittedly every traditional market already has a multi-sided element to it, here you have a platform, here you have an intermediary that acts between two different sets of users or customers. So in the case of payment cards, you have consumers and merchants and the issuer of the payment card, a three-part system, if you will. And that's the closed environment for a payment card. Or if it is like Visa and MasterCard, then you have an open platform, which means that there is a four-party mechanism. There is the issuer bank, the acquirer bank, the merchant, and the customer using the card. In academic journals, you have researchers and academicians who publish. In search engines, you have us as people who are Googling, hopefully. And then we also have people who are advertising on the search engines. And we could come up with further examples. Dating clubs, you know, they organize something. There are people who are coming in to date. And actually, it's very important to note that there is a mismatch in terms of the way they are charged. So the customer groups are charged differently. They're not charged exactly identically, and there could be efficiencies in doing it exactly that way. So employing traditional antitrust know-how and employing traditional antitrust bright line rules of thumb might prove to be counter beneficial in multi-sided markets, because multi-sided markets might have intrinsic dynamics of their own that are bringing us different points of equilibrium, which may be very easily messed up with if we were to use easy formula. So in the multi-sided market, basically you're looking at network effects, and especially the external network effects are quite significant, in the sense that the more you expand the area of influence of one market, the more you subscribe more users into it, the more the other side of the market is going to benefit from it. So in other words, the utility gained by one side of the market is substantially going to increase if the popularity of the product is increasing at the other side of it. If more people are engaging in the search, it means the utility of the advertisement givers to the search engine are increasing and such. If the credit card is being used by more restaurants, then more consumers are going to subscribe for that credit card. In turn, more restaurants will want to use that credit card, which means more banks are going to be allowing for the credit card to be issued and to be commissioned as acquirers. So to make a long story short, it is a self-perpetual, it is a self-feeding mechanism where popularity is the nucleus of the matter. It is the future of multi-sided markets. And one side is typically subsidized in this environment. So one side has the ability to say, well, you need me. I don't know that I need you that much. And that guy has to be subsidized. In easier terms, we said we're going to simplify it. We could say that in the dating mechanism, the ladies generally get subsidized in the dating commissioning markets. So the ladies would say, all hell would freeze over if I am going to be taken on a date and I will be paying for the commissioning of the mechanism as well, the dating matching mechanism. In Turkish terms, we could say, "Aa delinin zoruna bak ayol, bir de üstüne para mı vereceğiz?" Now, the real issue, therefore, is finding the appropriate payment mechanism. And that is the key word. If you're going to leave with any bright line rule on how to govern multi-sided markets, it has to be that there are appropriate payment mechanisms, appropriate commissioning mechanisms that maximize welfare. And if you were to employ quintessential antitrust theory and therefore start interfering too much with these appropriate payment mechanisms and the subsidization that I am talking about, then the products may not be born at all, depending on at which point in time you proceed with your legal policy preferences, or the products that have been successful may not expand as such. So that's an extremely important issue. And we would see that multi-sided markets would take competition authorities out of their comfort zone. We said multi-sided markets are a little bit magical. Where the magic happens is outside the comfort zone of the competition authorities. So competition authorities everywhere in the world will have to follow the lead of economical analysis and will have to leave their own comfort zones and their train of thought of very many years from getting entangled with more traditional markets, and they would have to look into these markets properly. What kinds of markets could we be talking about? As an attorney, I am representing a search engine, that's a multi-sided market. I'm representing a payment system issuer, that's a multi-sided market, a ticket voucher, a meal voucher ticketing system. The staff taking their tickets to restaurants and paying with tickets issued by their employers, that's a multi-sided market. And anything and everything could really turn into a multi-sided market. As well, anything and everything could have network externalities to it. You might be thinking that you're simply purchasing a computer, and that's a traditional transaction. But actually, the more you have the idea that you should be buying a best-selling computer because it's likely that the most cutting-edge software is going to be calibrated for that, suddenly you are still looking at network externalities. So what I'm saying also is that it is not very easy to find where network externalities are starting and finishing, and it's also very not easy to come up with a bright line definition of what a multi-sided market is. You have to pass that judgment on the basis of each case. As we said, one side is usually subsidized. When defining the relevant product market, we have to leave our comfort zone. The sides are generally interdependent. So that interdependency will have to be taken into account. While measuring the market power, we have to leave our comfort zone to find the magic, because if we were to use the traditional analysis of price versus cost margins and the wedge between the price and cost margins being too high, being a proxy of existence of market power, then again we're going to probably come up with a perverse legal policy, because it is always necessary to bear in mind that one side is usually subsidized, so you have to have a view on both sides of the market at all times, and you have to develop a holistic view of the marketplace. Again, the network effects and the barriers to entry will have to be seen together and under a different light. Yes, attaining the network effects are actually a matter of barriers to entry, because it has to do with size and scale, which means that it is not easy to attain at the point of entry. But then again, the platform has to keep both sides happy at all times. So there's a built-in mechanism of keeping the multi-sided markets competitive. Again, there could be multi-homing very easily. I said hopefully you're Googling, because I represent Google, but you could be using Yandex, you could be using other companies. So in short terms, I think one can say that the network effects are not always only barriers to entry, but they might also be functioning as bringing equilibrium into the marketplace. You could be going for a quintessential case of price discrimination, and later you might be realizing that actually it's not really price discrimination, it is just the one-sided subsidization that I have been talking to you about. Or you could be going for predatory pricing, saying there's another company trying to get in the dating websites market, but it seems the incumbent dating website is not getting any payment from the ladies at all. Isn't this below cost pricing? You're developing an analysis that is too narrow, and therefore you are developing an analysis that is going to kill the multi-sided market. You have to always keep in mind the totality of the circumstances while regulating the multi-sided market. Again, looking into restrictive agreements, a very recent case, and I have presented this at Bilkent University a month ago, the Groupement des Cartes Bancaires decision, where the General Court erroneously found, according to the decision of the ECJ, that the restrictive object is in existence because it failed to consider the interactions among different sides of the market and the network effects. So the ECJ actually saying very, very recently that you have to always keep your eye on the ball. And the same thing would be happening in merger control issues as well. Two case studies that I'd like to talk to you a little bit about in the paper. This is explored in great detail. The first thing that is necessary to know about the case, the MasterCard case that I'm going to talk to you about, is that there are two different systems, the closed system and the open system. We will be talking about the open system. So the players are, you have the customer, the cardholder, you. It is ironic that I should be telling you all this, because I've never used a credit card in my entire life, but a lot of people use credit cards. And the customer, the cardholder, believes in something by holding the credit card. That is, it is going to make its life, his life, her life, easier. Then you have the issuer bank. It is your bank issuing the credit card to you, whatever bank you are using. Then there is the acquirer bank. You don't know about that bank while you go to the restaurant and you give it to the merchant, the Sampi. But when you give it to that particular merchant, that merchant's bank is actually talking to the issuer bank, the bank that has given you the credit card. So there are two banks, the merchant and yourself, four-sided. That's the open system. The closed system would be a different thing. I'm not going to go into the detail of it. It's the American Express model. And in there are certain fees. The fixed membership fee. You are already paying it. The issuer bank is charging it. And then there is the interchange fee. The issuer bank is charging the merchant's bank, which is the acquirer's bank. So the issuer bank is saying, here, a transaction is flowing through me. Had it not been for my customer eating at your restaurant, you were not going to get this money, dear bank. So here is some further charge. Now, all hell breaks loose about this charge because Visa and MasterCard and the other open systems are regulating that very charge because it is extremely costly and the transaction costs are extremely hard to manage if they were to engage in bilateral engagements time and time again between different merchants banks, i.e. Acquirers banks and the issuers banks. So what they do is they come up with the idea of a multilateral interchange fee. And the multilateral interchange fee really is a default fallback mechanism, if you will, where you know what the fee is going to be. But of course, we have seasoned enforcers of antitrust law here with us today. The minute competing banks are mandated by another association about what fees are going to be applicable, that is running into an antitrust problem. Why are you fixing this fee? Why are you coming up with this fee at the first place? Kinds of questions are emerging. At the very beginning, in 1984, that was not the case. It was that I'll be calling it MIF from now on, the multilateral interchange fee. The MIF was just the following in the Nabanco case. It eliminates the costly uncertainty and prohibitive time and expense of price negotiations at the time of the exchange. Wonderful. That's what the banks like to hear. That's what Visa and MasterCard and everyone likes to hear. Yes, someone understands our issue here. Then signaling of certain issues. In 2002, in the European Union, in the Visa case, the multilateral interchange fee was looked at again. There you see another thing. It says that the specific level of the MIF, or at least the methodology for setting the MIF, has to be shown to result in transparency. So I am getting increasingly skeptical about how this is being set. Are the merchants being taken for a ride? Are the merchants being compelled to come up with higher charges? Are the banks and the likes of Visa and MasterCard engorging themselves at the back of the merchants, is the question mark, which we believe is wrong. The question is wrong, and the answer they came up with also happens to be wrong, but it's an extremely important question of law and economics because the less economic analysis you employ in this matter and the more legal bright line rules that you employ, the more you're going to kill a multi-sided market. So basically, the price structure had to be observed very carefully, and the ECJ's decision in 2007 in the MasterCard case, therefore, was a bit of a problem for all interested parties. First of all, the ECJ was saying that perhaps there could be a prohibition of ex post pricing. So why don't you prohibit the use of this particular fee, was the idea that they came up with, if your defense as MasterCard is that they would be, the merchants would find it very difficult to negotiate with the issuer's bank because you have to accept all cards at all times. That's the rule. And yet this does not make much sense, really, because the more you push the MIF toward zero or toward the merchants' bank's marginal cost levels, thank you for this, the more you're going to find yourself in a situation where you actually don't know if you've done a good thing. Here is the most important sentence on this particular case and these types of cases. You do not know that you're doing a good thing, a welfare maximizing thing, by way of pushing the MIF to zero levels or toward marginal costs, because the more you decrease the MIF, you might be actually increasing the price at the other side of the market. And you have to develop a holistic view of the situation. Otherwise, overall, the multi-sided market might be losing, whereas you might be feeling, as the antitrust watchdog, you might be feeling that you're doing a right thing because there was a fee that was 10 units before and now it has been reduced to 3 units, or in some occasions you're seeing zeros. But actually somebody else is carrying the weight of that enforcement at that point in time or in the near future. So I'm going to pass quickly to another case that we brought to you, but on this particular note, and there are great details in the paper, it's difficult to squeeze it in to 25 minutes, you would find that the multi-sided markets handling has to be done in a particular sensitivity to the very dynamics of that multi-sided market. And not only all multi-sided markets, but actually with the empirical data produced by that very multi-sided market. And the second issue is the merger analysis case, which was very interesting. I just want to name it. I have about 2 minutes now, so I'm not going to be talking about a lot of details of this. But for future years, I think it might be evaluated if it's wiser to have less speakers and a little bit more time, I have to say. The merger analysis and I'm not assuming that I would be one of these speakers, I'm happy to bow out. The merger analysis in multi-sided markets is also extremely interesting. First of all, David Evans, who speaks and writes and thinks a lot about the multi-sided markets, has been quite keen on underlining that the SNP test may not always work. I have been privileged to work with David Evans along with Jorge Padilla back in the day when I was representing Microsoft in Brussels, and David Evans continuously underlines that the multi-sided markets law and economics has to be handled in a different way. Well, he would call it the economics of it would have to be handled in a different way. There are distinct consumer surpluses on each side of the multi-sided market, and therefore the price structure is very important. The one thing that I'd like to talk to you about, and then I'm going to be done with the presentation, is that this particular case in the Netherlands has been a case of 2 Yellow Pages companies coming together. So these 2 Yellow Pages companies basically accept advertisements, and they are printed. So the online market is excluded from the analysis, and it is a case of 2 to 1. As you might know, it is already 3 to 2 hard to do generally as a rule of thumb in merger control everywhere in the world. And when you're reducing from 2 to 1, you actually dearly need a fresh look to the relevant market, as we did in the Boyner purchasing YKM case, for example. Had it been a given market that is very narrowly tailored, then it was not going to be allowed. But when you included the actual non-food retail market in general, then it didn't look like 2 to 1 anymore, and it proves to be correct that it was a correct decision of the competition authority. As such, when the online market is excluded and everything else is excluded, the Yellow Pages found it very difficult because the printed Yellow Pages are only 2 and they're trying to come together. And the most interesting thing for the authority has been a very relevant thing, which is, are they going to keep 2 products as separate, or are they going to bring them together? We must always remember this as a very important question of analysis of multi-sided markets. So Filistrucci and friends in 2010 say something that at the first sight looks like contradicting Evans and Shemelansi of 2012. They say if 2 firms merge but still produce 2 distinct products, the customers are not necessarily going to enjoy a higher utility due to the indirect network effects. So don't be selling me indirect network effects if you're going to keep these products as separate, but you're going to, behind the curtains, consolidate. And Evans and Chmelancy say a merger of multi-sided platforms would ordinarily increase indirect network externalities by increasing the size of all customer groups. Remember the importance of popularity. So in shorter terms, I'm just posing one significant, crucial question that needs to be always asked in mergers that deal with companies that are active in multi-sided markets, and that is whether the products are also going to be consolidated, and therefore the entire sphere of influence is going to expand, bringing out efficiencies and also indirect network externalities, or whether it is going to lead to just a consolidation of positions and therefore harmonization without any significant gain in popularity. Thank you for your patience. I hope this has been useful.
The first question would go to Mr. Çelen regarding his presentation in airline industries, I guess. So the floor is yours, Mr.
My question is about the comparison between maritime transportation and air transportation markets. The question says that in the air transportation market, the markets are generally defined airports to airports. For example, the market, the product of Sabiha Gökçen to Esenboğa is different one to Atatürk, from Atatürk to Esenboğa. This thought is, this thinking is the same with ours. This is exactly what we did in this analysis. For example, as I said, my presentation, the most important line in our analysis is PTP. This abbreviation means that Pendik, Trieste, and pending. Different from the air transportation market, we defined return markets, not one-way market, because in the air transportation market, for example, if you fly to the Istanbul from Ankara, you don't have to use airlines in order to turn back to Ankara. Okay, you can use, for example, bus services to turn Ankara, but it is not valid for the ro-ro market. For example, if you are a logistic firm and you send some stuff to the, for example, Germany, and you have to use this ro-ro line again because you sent your trailers to the Germany. Okay, so you have to use the same line again. So we prefer to use return lines, for example, Pendik, Trieste, and again pending. Okay, so the thinking is the same with airline market, but we have to use return tickets. Okay, so this is my question. Is enough, Miss Aslece Kural? Okay.
Thank you very much. And there was a question for Mr. Gürkaynak.
This is coming from Onur Çağdaş Artantaş at Hacettepe University Law School, and from the handwriting I remember that this is a student, and I remember him as well, and it brings me back all the horrendous memories of trying to read this handwriting. Uber, an inner-city transportation app, took advantage over licensed taxi drivers thanks to its ease of payment and possibility to comment on drivers, thus created a multi-sided market in this sector. Should public privileges of licensed taxi operators be protected? What would be your policy suggestion? So, wonderful example, Uber is a newly created multi-sided market, and it is therefore important to note that it is having some impact on the licensed taxi operators. My personal view and professional view too, because I'm involved in the sector as well, is that increases in technology are by definition, increases in technology are by definition good. So multi-sided markets can be invented, as it is the case with Uber. But for you to be able to invent the market, there would have to be the multi-sided synergies, and there would have to be the multi-sided market demand from the public. It may be unknown to the public, but it is almost a tipping of the situation when you invent it. For ordinary people like us, it may not occur to be a very natural thing, the evolution of a multi-sided market. If you were to come to me with the idea of yemek sepeti, I would have probably thrown it out and not invested in it, but it just got sold for more than $550 million in Turkey, because I would have said, well, when I am hungry, I need to cry on the shoulder of some flesh and bone human being, and I need to explain to them over the phone how hungry I am and why they should send the food right away and all. I can't trust a computer for me to do that, but apparently that's not how human beings operate, and someone has taken that risk and has turned it into a market, thereby expanding the market. So the last sentence on this is, I think the privileges of licensed taxi operators or anything that has to do with protecting the incumbents need to be discounted against the new efficiencies and the new marketplace dynamics that are going to be formed through the encouragement of multi-sided markets. So I think Uber and any other new multi-sided market would need life juice at the beginning, and that can be done with a lenient approach on this particular angle.
Thank you very much. And there's a question also, Ms. Butts, and after she answers her question, she has a question for Mr. Gürkaynak as well.
Sure. Yeah, thank you. So it's rather to ask your opinion on a certain matter, because we have been doing also some research on Google, on Facebook, for example. And from the economics perspective, it's quite difficult to quantify certain things. So one side, of course, is easily quantified because you have the advertisers and they're paying a price. So this is an amount of euros, so we are happy. The other side, of course, is a bit more difficult because you have, for example, in Google, the one who is searching, he doesn't pay directly in euros, but in a way he pays in data. So Google collects the data from him. So somehow we would like to quantify this. And then we were brainstorming a bit, and then the idea came, maybe we can quantify, if we would ask someone who is searching what for him the value would be, or what he would be willing to pay for Google not to collect the data on him, or Facebook, or whatever. Would you think this is a valid approach to the topic, or do you have other suggestions in this regard, maybe? Yeah.
Thank you. This is an extremely interesting approach and question. It's difficult to compare these two. I think it is kind of an apples and oranges situation. So, first of all, I am lukewarm to the idea that searches are costly to the searching individuals in the form of them giving away information. Yes, of course, the Hadoop and the big data mentality in general may mean that certain data is collected, but it would readily mean that it is costly to the individual searching because there is a breach on their data protection, their privacy, whereas the algorithm and the lack of manhandling in the entire process, in my view, makes it certain that that kind of a cost is not being incurred. But if you were to go and ask the individual who is doing the search at that point in time, they may not be aware of the internals of how this is being submitted and what is happening, so they might feel, oh, okay, someone is cataloging what I am providing and I am being traced right now, so there is a cost of it. I would say my privacy is very important, so such and such figure. And that would be misleading. I think it would fall into a lot of fallacies. But I think the idea is very interesting. It just should not be compared with with the multi-sided market dynamics, as it's not truly a cost function. I think it ceases to be a cost at the point in time where you get the information you need without any cost. And whoever provided that information to you gains something out of it. And that guy is chased after through advertisements and whatnot. And even there, the cost function is dispersed and diverse, because not all advertisers are benefiting from Google's services, and vice versa. Not everyone who is benefiting from Google's search engine is coming up with advertisements over Google. Yeah? All right. Thank you.
Okay, yeah, so thank you, Abdulmalik, for the question. So the question is whether or how adverse effects are determined, and whether there is a conflict maybe with prohibited subsidy definitions in EU law and international trade law. So to go into the first aspect of the question, adverse effect, how is it determined? So basically in EU policy, you make this kind of balancing exercise. This proposed state aid comes in, and the Commission will then look, okay, is there an incentive effect? Does this state aid really alter something in the market? Is it kept to a minimum? Were there no other policy instruments that would achieve the same thing without giving an aid? For example, this is the case in these environmentally friendly investments. Okay, we want to subsidize them. Of course, the alternative would be that you tax more heavily the more polluting alternatives. So isn't there another means than the state aid? And this is then balanced, the possibly positive effects to the negative effect of competition distortion. And this is really more like a real balancing exercise where the policymaker says, yeah, the positive effects outweigh the negative ones or not. And then the conclusion is made. We measured purely the adverse effect as the effect on competition. So in our paper, we didn't look at any positive impacts. We only looked at measuring potential distortions of competition, or impacts, if you don't want to call it distortions, impacts on market shares. Whether I see a conflict with international trade law, well, state aid control is quite specific. State aid control framework in the EU, I think it's quite unique. At the US, they have state aid, they don't have state aid control. I think the only other jurisdiction that I know that has a state aid control is the West African Union. They somehow played a bit copycat on our competition policy framework and copied also the state aid control, but it appears to be not really enforced there. If you would, of course, compare to WTO rules about subsidies, etc., our EU framework is always a lot more strict, taking it one step further, where WTO looks at export subsidies and these kinds of things. So, which is good that our framework is more strict, because we don't run into any issues in that respect. Of course, only with regard to our agricultural policy, our horrible agricultural common policy, where we do have a lot of criticism from outside, the way we are subsidizing our farmers, our agricultural industry. So a conflict, yes and no, we're going a lot beyond what the WTO, for example, says. However, always with the exception of agriculture, I would say.
Thank you. I would like to thank all the participants for their presentations and contributions for our conference, and for your patience. But I had a preference for food for thought rather than lunch, and thank you for your understanding on that as well. And the lunch will be served, I guess, and you have the announcement on that.